All right, good evening, depending on where you are. My name is Mr. Max Chaudhary from Chaudhary Law Office. I just want to start by asking, perhaps somebody in the chat can let me know the answer to this question. Can you hear me? And you can
Yes,
send a message. So I hear a
yes,
yes. Okay, that's great. So then the way these meetings typically work online is that I receive questions in the chat and I endeavor to answer those as reasonably as possible, keeping in mind that this is distinct from a comprehensive elaboration about a question, because that's normally associated with something like a consultation where we ask for history and circumstances of a client's, for example, interactions with the immigration authorities and their goals, etc. By contrast, when we do this kind of webinar setting, then the idea is at least to give some general direction to the query you may have. And the way you do that is you avail yourself of the chat feature in the Google Meet. And then I can read the question, and if necessary, I can ask for some elaboration. And thereafter, after I receive sufficient detail about the question, then I can endeavor to answer the question. Keep in mind that the nature of the answer probably is just for the point of general guidance as opposed to having or being actual legal advice, because there are sometimes caveats, such as the need for whether or not a particular law has changed or whether or not case law surrounding a particular statute has changed. And with those kinds of caveats, nevertheless, I hope this can provide some general guidance, especially given the fact that the way the immigration system works, combined with the online nature of almost every service, means that you can avail yourself of various forums and venues, such as the immigration website, to try to get some background to the question. But sometimes these venues, such as the immigration website and various fora, may be not as useful because they may not particularly speak to the issue you have. So, with that in mind, I'll just send a little reminder, because people tend to come in at various random times, to please feel free to pose a question in the chat here, and then I will wait in the meantime. And keep in mind, this is being recorded. I'll send a message as well in the chat. So that means, as a matter of prudence, it's a good idea to be anonymous, because the sort of surveillance nature of the many things requires, especially with sensitive legal issues, to try to maintain some confidentiality about these kinds of things, just because you never know what can happen. And this is also meant to provide introduction to my law firm, which provides Canadian legal immigration services for people who have various scenarios, which could relate to permanent residency or temporary residency, or the other more what we call enforcement minded types of law, such as exclusion orders and removals from Canada, or appeals against negative study permit decisions, or negative permanent resident or negative temporary residency decisions, which may necessitate an appeal at the federal court or the Immigration and Refugee Board. So, with that in mind, let's dive into the question I see here. Thus far, the question being posed is as follows: Is it possible to start an express entry application without an IELTS general score? So, broadly speaking, you could commence it without an IELTS score, but the precise response is that you need a language test. So now there is IELTS, CELPIP, and there's a newish one that escapes me, but you can find that on the IRCC website. So when you think of express entry, think of the third-party documents that you must arm yourself with before composing the profile as comprising minimally the valid passport with the passport number, obviously, IELTS test less than 2 years old, educational credential assessment if you did have foreign education less than, I believe, 5 years old from the date of submitting the profile. And I think those are generally the documents you need. And it's a good idea to know what the job duties you performed in the past years are, because you are asked to compose a summary by inputting a specific knock code or codes in that profile. So that's where legal advice might be prudent. So that's the somewhat detailed answer to what's ostensibly a sort of brief question. But with that in mind, we still have plenty of time here. So, um, yeah, so the IELTS test has to be the general, because there's sort of a follow-up question. If it's the academic, then it might be a negative situation where you actually get accepted and then they discover after you filed the application for permanent residency, also known as the APR, that you submitted the wrong test. And as a result, they would deny the application, which seems counterintuitive because from my rudimentary understanding, an academic IELTS test should be considered as significant in terms of assessing your ability in the English language, just as useful as a general test. But nevertheless, you must have a general IELTS test or the CELPIP or that other test. Again, the name escapes me. So those are the essential surrounding questions about third-party documents, the IELTS and the express entry profile. Anybody new joining, I'll just send a reminder orally and in the chat. Please pose your question in the chat. In the chat. And I'll review those periodically and then endeavor to answer those. And in terms of sort of essential background, oh, okay, so we see people joining. And as a reminder, please feel free to pose a question in the chat. And in the meantime, while I look at the chat, there is a question. Please explain the OINP application process. So that refers to the provincial nomination program by the province of Ontario. So I was going to say that it depends on which pathway, such as entrepreneur versus employment-based worker. But now currently the Ontario Immigration Department has paused the entrepreneur program, but that still means that there is the program based on education or work. So there's the international student stream. And if you have work experience in Ontario and you have an employer who's willing to submit to some scrutiny showing that they have a certain amount of income, I believe it's $1 million within the GTA, and also with the depending on where the company is, I believe outside the GTA, if they have $500,000 of gross income and a certain level of employees, then they could support your application for permanent residency and you get additional points. So that's one aspect of the Ontario immigration nominee program. Another one is the master's or PhD stream, where if you graduate from a master's or PhD stream and within 2 years file an application with the Ontario authorities saying that I intend to reside in Ontario, that could be another pathway for permanent residency under the Ontario PNP program, right? So with that in mind, that's a sort of a rudimentary explanation of the Ontario PNP program. And I think a related question is there an IELTS requirement for the Ontario immigration nominee program? So with the Ontario immigration nominee program, oftentimes, depending on which program you're thinking about, sometimes it's embedded within the federal express entry program, some of the Ontario permanent residency programs. And in those circumstances, you would need an IELTS test to be considered under those. So you may as well presume that that's generally the case, that to have a IELTS test. And then I see a related or a different question rather, which is there any difference between a work visa or permanent residency in terms of working in Canada? And which one is easy or easier to get in a shorter time and without a job offer? So when we look at a work visa or work permit versus permanent residency, those are two very different types of status, because one is basically time limited in a very restricted way, the work permit, usually 1 or 2 years. Whereas the permanent residency, once you acquire it, as long as you maintain the obligations as a permanent resident, the duration could be for the rest of your life, unless you convert it to Canadian citizenship. So those are sort of some elemental differences from the outset. But in terms of which one can you acquire in a shorter time, if we think sort of in general terms, then permanent residency tends to have, depending on the program, such as the express entry, it has stages such as the express entry profile, then the invitation to apply, then the electronic application. So all of those steps could take as little as 7 months or could take 2 years, depending on the combination of circumstances, the job you came under, and some luck. By contrast, a work permit, depending on the country you're applying from, could take 11 days. It could take a year and a half, depending on the country you reside in. So this is, I suppose, an illustration of a lot of the subjectivity and randomness in both subcategories of Canada's services related to permanent residency or work permit. In other words, there is a broad range in terms of ease and processing speed of these. Another example is permanent residency through the spousal category. In that situation, it's sort of a hybrid, because if you opt for an inside of Canada application, and in theory, an outside of Canada application, you can also apply for a work permit. Anecdotally speaking, since COVID, it seems that although this option is available for common law or spousal applications, it seems that the processing time of the work permit sometimes takes so long that the permanent resident spousal or common law application actually gets decided before the work permit is issued. That may change now because COVID is subsided over the past year or so, and then the presumption is the processing times for many of these applications will go up. So The sort of related question, I think, from that is, can you get a work permit without a job offer? So a work permit without a job offer is typically associated with what we call an open work permit. An open work permit is something of a creature of policy, where the government of Canada has said that in order for Canada's immigration department to be competitive in the world, to attract skilled workers, for example, a work permit holder can bring a spouse. So that means the initial worker could be on what's called a closed work permit, i.e., a work permit tied to a specific employer, but they could bring their spouse, and their spouse would be available to file for an open work permit. So that means, for example, if you're the spouse of a closed work permit holder who's working in Canada, you don't need a job offer. You can apply for a work permit. So that's one example. A similar one is after you have filed the express entry and received an invitation to apply and filed your electronic application for permanent residency, then you could apply for a bridging open work permit. And that's an open work permit as well. But when you realize the steps I've just told you, express entry profile, invitation to apply, electronic application for permanent residency, and the acknowledgement of that, that's quite a few steps. That could be, as I said earlier, anywhere from 6 months to a year for that to occur. So I hope that's illustrative of the, at least in a general sense, the pathways for getting or comparing permanent residency speed and availability versus a work permit. And if anybody else is joining, I think I heard some electronic chiming in. Please feel free to pose a question in the chat, and I'll endeavor to respond to that with the caveats that I mentioned earlier. And let me just look at the chat at this stage. So we see, I may have to alter or truncate the question or ask further detail, but let me take a look. So the question is as follows: if I create a profile in the express entry pool, does that also make me eligible for the skilled trades and occupations category draw? So it sounds like this is a reference to the phenomenon of targeted draws that the federal government has imposed on the express entry system since, I believe, May of 2023, where although there are draws that are regular, nevertheless, sometimes the draws are focused on certain categories only, like federal skilled trades or provincial nominee, or targeted in terms of the occupation, such as STEM jobs, science, technology, engineering, mathematics, or healthcare, or based on having a certain level of French language skill. So the issue with that is that the ordinary, for example, Canada Experience Class draws are becoming fewer, those general draws, and they are being supplanted by these targeted draws, which, although they require less points than the general Canada Experience Class draws, nevertheless, they are fewer candidates who have STEM work experience or healthcare work experience. And that means there is a dwindling pathway, practically speaking, for those study permit holders who did not study in STEM or healthcare related jobs in the past 3 years or so. So this is leading to frustration on the part of those candidates who may have opted for non-STEM related courses of study, such as finance or things of that nature. So that means When you create an Express Entry profile, the knock code is inputted by you, and then you may automatically get selected for the targeted draw if you did have 1 year of work experience in Canada in a STEM related job or healthcare job. I had a client the other day got selected based on being a pharmacy technician, which is a knock tier level 3 job, I believe, but it's at a sufficient enough tier, and it was in healthcare. So he's on his way to file his electronic application for permanent residency based on that targeted job for healthcare. So I hope that gives sufficient background to that question. If anybody's joining, please feel free to pose a question in the chat, just so we can get some utility out of this. And as I always remind people, if you look at the beginning of this chat, this is being recorded, and some of this may end up as being archived on the internet because it is general information about immigration, and we all want to disseminate some form of immigration information for our purposes and for your benefit as well. So take a look at the chat here. Okay, so nothing new in the chat. We still have plenty of time here. So that means in the meantime, until I see, oh, wait, let me take another look here, right? So there is a question related to study permits. So how much money do you need to show when applying for a study visa? So before the changes in January 2024, excuse me, which were far-ranging changes related to study permits, there was the proof of tuition for 1 year, which had to be shown, and proof of living expenses for one person for 1 year for, I believe it was 10,000. Now I believe that amount, I think, is 20,000 since January 2024. And you still have to show the tuition for 1 year. So if tuition is, for example, 15,000, then you'd have to show 20,000 on top for the living expenses for 1 year. So that could be 35,000. Excuse me. So that's a reflection of the changing of course of the federal government, where the provinces now are subject to allocations of study permits. This is meant to spread out the benefits of international students to institutions of learning across the country. So it's compelling future international students to file for study permits in smaller provinces. And that's of some benefit for the Canadian public as well, because that allows for economic growth in those smaller provinces. So next question I see here is it possible to apply for an H&C, also known as humanitarian and compassionate application, outside of Canada? Because I have 2 Canadian-born children, and I have been outside of Canada for 9 years. So will I be eligible? I'm assuming the person is outside of Canada based on the context. So in theory, a humanitarian compassionate application historically has been done in the context of people who failed to meet the category of family class. The H&C, or humanitarian compassionate regime, is restricted, has been more and more restricted for people outside of Canada. So for example, if you are an economic candidate, such as under the federal skilled worker category, there no longer is a humanitarian compassionate application you can meet as a backup to the federal skilled worker application. Anecdotally, we filed in the past humanitarian and compassionate applications For example, the somewhat opposite situation for what's being posed, namely a Canadian permanent resident or a citizen adult who wants to file for their child under humanitarian grounds because, for example, the regular sponsorship is not available either because the child is too old or because maybe the child was not declared, which bars them from being considered as a member of the family class. And the procedure we used in that scenario is we filed it as if it was a sponsorship, which typically goes to the office in Mississauga and then gets sent to the appropriate visa office. And with a notice by the Mississauga office saying you don't qualify as family class, but we'll forward it anyways. And in that scenario, we have had some success in having a humanitarian application submitted, which is somewhat of a vaguely analogous situation. In this situation, I think there's a theoretical possibility because at least prior to January 2020, children who were permanent residents or citizens could sponsor their parents. I mean, then it became a lottery. Now they've paused entrance into the lottery, and that has led for some candidates to file humanitarian compassionate applications for that family class member, namely parents who are inside of Canada. Then the way this question is being posed is the children are Canadian, I'm assuming outside, and the adult parent of the Canadian is Canadian children is outside of Canada. The children are Canadian, so they don't need an application, but the parent is not Canadian, and they need an application. So I would say theoretically it should be possible to file this. It's statistically speaking, the chances are way better if somehow you are in the country, then it's a generic humanitarian compassionate application, because the vast majority of humanitarian and compassionate applications are filed for people inside of Canada. The example I gave earlier is one I can think of which we filed where the person who was the subject of the H and C application was outside. So I'd say a qualified yes in terms of whether that is possible. But as if you've researched H and C applications, the cornerstone of a successful application is oftentimes, but not always, the best interest of minor-aged children. So in other words, how would a negative decision on an affected family member, like a parent, have on the minor-aged children, i.e. children who are under the age of 18? So in other words, if it looks like the failure to grant permanent residency to the non-Canadian parent, if that would adversely affect the children's interests, then that could be a strong factor to militate in favor of granting the H and C application. But H and C applications are fraught with numerous requirements because the criteria is intentionally vague and broad, just so as to encompass a broad set of circumstances and keep in mind the mindset of the officer dealing with the humanitarian compassionate application is such that they're looking for something that stands out. So then what stands out is a significant degree of hardship and difficulty for somebody affected by the inability of the candidate to become a Canadian permanent resident or citizen. So that's some background to this. And that also means something about the current circumstances of the parent and the Canadian children in the country they're currently residing in. Are they living an ordinary life, or are they targeted or subject to some particular difficulties which cannot be alleviated by, for example, moving to a different part of the country they currently live in. And other examples like the potential for economic establishment of the parent slash candidate who wants to be in Canada with Canadian status with their Canadian citizen children. So those are some of the factors that are related to that kind of assessment. So if anybody is joining, then please feel free to pose a question in the chat, and I'll endeavor to answer that in as much context as possible for this. And then we will see where that goes, because we still do have time in this webinar. And I'm surprised because we've been hearing a lot of information in the news about the uptick in removals of people who have been illegal in Canada, and this has led to a profound increase in deportations and things of that nature. And oftentimes we do get questions in the past couple of months related to that, but yeah, maybe that will materialize soon. The issue being that some people may have built up a life in Canada. They may even have family in Canada, and then there could be a separation of family. And as a result, there could be undue hardship on the family that does have status, that is remaining in Canada. And that could lead to a separation of, for example, a Canadian child from a parent who failed to regularize their status. And that could be the basis for what's called a stay or pause of removal, or a humanitarian compassionate application. So at that rate, let me take another look at the questions here. Is that looks like a related question to a previous one, namely, can one show money in the parent's account when applying for a study permit, or must it be in your own account? So I'm presuming that question is related to a study permit application, and based on the fact that parents typically do foot the bill for the education of their child, then credible proof of the parents' source of money, such as maybe they have a business or they have a job which has allowed them to accumulate savings, can be the basis for showing that you, as a potential study permit holder in Canada, do have sufficient access to funds. So the short answer is yes. Keep in mind the increase since January 2024, however. And as I mentioned earlier, related to study permits, there's the new requirement of a provincial attestation letter, which means that could pause or delay the issuance of your study permit in this current regime, because that could take time, because there is an interplay between the provincial school or institution and the provincial government, which has to lead to this allocation of a certain amount of these letters for each province. And in some cases, the fear or the concern is that if a province you've sought study in has already reached their quota, then your admission would become basically nullified, and then you'd have to alter your study permit application, or perhaps resubmit your study permit application to reflect a different school, which does have a provincial attestation letter for this. On a related note, there's a announcement recently of a new program for French speakers, and that will allow them to study and have a pathway for permanent residency as well. You can look at a recent TikTok entry I have, and you can also Google that. And I believe there's a blog post on our website that talks about that as well. The advantage for that is that if you do have French-speaking language skills, they're openly stating that this is a pathway for permanent residency. And that's a reflection of the government's desire to have more French-speaking immigrants settle in Canada. So that's a little bit more background about the evolving nature of study permits, where from before it was sort of an unspoken assumption that the purpose of the study permit was to forge a pathway for permanent residency, which was unspoken, but now that unspoken understanding has been, for many people, completely shattered, versus the recent new announcement, the one I just mentioned, which is saying that study can be a pathway or permanent residency. The implicit assumption is that you have to complete the program and settle, typically in a less populous area that has a French-speaking population. That would be the only caveats. And you'd have to demonstrate some support from that community as well, which may or may not be difficult depending on the community. So something to consider, which is along the nature or along the lines of these targeted draws for permanent residency, as I mentioned. It's not just STEM or healthcare, but also French speaking and French comprehension candidates for permanent residency will get preferential treatment for that. Something to keep in mind if you're considering studying in Canada. Consider studying in a STEM job or healthcare, things of that nature. And then the unspoken assumption that undergirds the CEC program, namely that studying should lead to permanent residency, will actually still be borne out post January 2024, which is when the profound changes took place in the study permit regime in the Canadian immigration system. So with that background in mind, I'm looking at the time. Yeah, we still have plenty of time. And the ultimate goal for most of the candidates is temporary status to transition to permanent status. It's very rare that we see people who just want to work or study in Canada, which is a huge contrast to what it was like 15 years ago, when there was no charted pathway from studying to permanent residency. It was very discretionary. So, in other words, the system is subject to certain ebbs and flows, and as a consequence, this leads to changes which take place, and the potential negative consequences for people who are in the middle of a process for transitioning, for example, from student study permit holder to permanent residency. So the example we see in the recent past is people who have embarked upon, for example, an e-commerce diploma at a publicly funded college or some form of finance-based job. And the nature of those jobs is definitely not STEM unless there's some very specific data analysis going on. And as a consequence, the people who pursued those studies in the past 1 or 2 years have severely seen their chances of success for permanent residency truncated due to the targeted draws which have been taking place since about May of 2023. In those circumstances, if you have the resources, it's good to change the course of study to something related to STEM or healthcare. And that could still preserve, albeit with more study, that could still preserve a pathway for permanent residency under the targeted draws of the CEC or Canada Experience Class subcategory of express entry. So again, people sometimes get victimized by these changes, which is, I guess, the nature of the law sometimes. We see that. And it's very frustrating. The other phenomenon which people tend to gravitate towards is what somebody did touch upon here, which is the humanitarian and compassionate category, which is in fact a kind of general catch-all category which is meant to alleviate hardship for people who don't fit a specific immigration program, but nevertheless have a significant degree of economic establishment in Canada and would have very noticeable hardship if they were to be forced to leave Canada. And so we do see an uptick in those applications in the recent past, owing to, for example, the de facto pause of the parent sponsorship and the kind of up and down hyper specific exclusionary nature of express entry. So with that in mind, let me see another question here. So we see somebody here saying they filed a refugee claim in 2013. It was unsuccessful, leading to their deportation from Canada in 2015. And how to apply for humanitarian compassionate on the basis of the best interests of children. So the closest method I've seen is if you file this as a family class sponsorship, which means a number of electronically submitted forms are under the family class category or package, and then those get electronically filed with the case processing center in Mississauga. And that case processing center would say, this is not a family class application. And they should give you the option to have the case forwarded nevertheless to the visa office where you reside, presumably with your children. And then they should make an application reviewed by them and come to some decision. I've only seen this work when the parent is in Canada and the parent is a Canadian or permanent resident, and the child is outside of Canada, as what does happen sometimes when the child is not sponsorable because of age or not being a member of the family class. So I'm taking a qualified guess that this might be a similar pathway to pursue for humanitarian compassionate, where it's the adult who is the foreign national and the presumably underage children, yes, underage children, who are the, although they're not qualified to be a sponsor, they are nevertheless Canadian, because to be a sponsor, you have to be 18 years of age. And if you're sponsoring parents, you have to be a successful lottery winner, because the parental sponsorship system requires you to have been in the 2020 pool and get selected from that 2020 pool. It remains to be seen if they will reopen the amount of parents that could be sponsored. Now it's 2024, halfway through it. They're still drawing from parents who are listed in the 2020 pool by their Canadian permanent resident or Canadian citizen children, which leads to some form of distortions of the immigration system, particularly by those parents who came to Canada under visitor visas or the longer term visitor visa known as super visa, where they can reside in Canada for 5 years. And in a sense, it's almost inviting those parents who have been here for a number of years on a super visa to file for a humanitarian compassionate application, because they've effectively lost any ties or establishment to their home country. And by contrast, they have a tie to Canada, namely their Canadian son or daughter. And they're getting older and they don't feel comfortable going back to their home country, so they opt to file an inside of Canada humanitarian application. And again, that's very subjective. A lot of hardship may have to be demonstrated, and some form of economic establishment consistent with somebody over that kind of age would have to be demonstrated. With that in mind, I see another question, which is, a study permit application was denied because of insufficient funds, despite providing enough funds. So the course of action in this case is unfortunately quite limited. So, in this type of situation, there is a request for reconsideration option, which is kind of, as the name implies, you just ask them to look over the application again, saying, can you please look at page 17 of the application, which clearly shows uh, bank statements certified by a notary public showing that my father has the equivalent of 100,000 Canadian dollars in local currency, and it's been sitting in his business bank account for 6 months. And then it's logical to say, you officer, I respectfully say you made a mistake. Here's the proof. The problem with this reconsideration pathway, however, is that there is no discipline to the process, which means that an officer is not bound by law to make a decision on your reconsideration application. So then you may ask, what is the usefulness or utility of making a reconsideration application? Sometimes the utility or usefulness of a reconsideration application is amplified if at the same time you seek what's called judicial review at the federal court, because in that case, then the refusing officer who refused the study permit would be put on notice that, number one, you filed a reconsideration application, and secondly, a judicial review application has been filed at the federal court. And this means that you have preserved your right to seek judicial review by filing it before the deadline. And then this gives the government lawyer who defends the officer who issued the negative decision on the study permit, it gives that government lawyer the option to talk to his or her superior and say, I'm defending this study permit officer's refusal. It looks like there's an obvious mistake. Plus, the candidate has filed a request for reconsideration, and it looks like the request for reconsideration was not considered. And it looks like the chance of success for the government to defend this decision is low. Sometimes that just one additional step of the reconsideration combined with the federal court application can lead to a fast resolution of this refusal, because it's not in the government's interest to defend a weak officer decision, which can be challenged, because what happens is, if I recall correctly, the immigration department has to pay the federal government's Department of Justice money to defend their decision. So it's in the interest of everybody, when it's an obviously wrong decision, to simply settle the case. And we've seen that happen when there's an obvious mistake, such as saying you did not provide a police clearance, and we clearly did. We do the reconsideration. Sometimes there's an answer within 7 days, but if there is no answer and the deadline for court is coming up, then we file the judicial review, and sometimes that combination leads to the refusal being set aside very quickly because it saves the government lawyer time and money. So that's a potential way to deal with this, i.e. reconsideration plus filing before the deadline judicial review application at the federal court for this. And just from a general point of view, the government operates, or the immigration department specifically operates, under the presumption that if they make a mistake, most people don't go to judicial review unless the stakes are high, like maybe there's a potential separation of family depending on the decision. And then the person's more inclined to file for judicial review, but that's not very common. Other people who, for example, have a failed study permit application, sometimes if they see there's a pathway for permanent residency in New Zealand, they just try to file something in New Zealand, right? That's fine. The only issue is sometimes these other governments ask, have you ever been refused entry to any other country? that could be a problem. I'm not a New Zealand immigration lawyer, but I've seen, at least when a person is seeking entry to Canada and they have a refused application from some other country, at the very minimum, it slows down their Canadian application because sometimes it leads to further questions or what's called a procedural fairness letter, depending on how much of this issue was disclosed at the outset of your Canadian application, which embeds this refusal from another country. So there is some complexity to this kind of scenario. And whenever there's an application that has some kind of complexity, that's one example, which is a refused application in the past, or some other complexity, such as maybe a criminal charge or a criminal detention or criminal conviction. This could lead to the need for some more extraordinary applications, such as an authorization to return to Canada or a temporary resident permit on top of whatever application you were seeking to Canada, such as a study permit or a work permit. So the idea is that although the Canadian immigration website strongly encourages you by providing at least the forms, it strongly encourages you to file everything on your own. They don't care if the application's refused, because if you pay the government fee, they get a line of business that way, and they can refuse the application and keep the government fee. This leads to, as I mentioned, somewhat of a negative record, which could be challenging when resubmitting an application to the Canadian authorities or resubmitting an application to some other foreign government for a study permit or work permit. That's something people don't realize. And in those cases, sometimes if it is what we could characterize as a wrongful refusal, or a refusal that does not cohere with what was submitted, such as a police clearance, which is allegedly not there, but is in reality there, then strongly recommended to seek advice about judicial review at the federal court. By contrast, certain types of appeals are embedded in the law, such as if you sponsor a spouse from outside of Canada, they have a right of appeal most of the time. Not the person being sponsored, but the sponsor. And as long as the person they sponsored did not have a serious crime in the past, or committed human rights violations, then they can appeal the refusal to grant permanent residency as a spouse, because the presumption is, in those cases, the officer thought the marriage or common law relationship was not genuine. So that's another example of the need to seek some kind of redress instead of resubmitting an application, such as a refused spousal application or refused study permit application. So we're coming up on a few minutes left. So I don't know if I'm going to give you your time short, unless there's a further question about this, because we still have a little bit of time. But if not, the idea, generally speaking, is, I do see a related question. So it says, I presume related to the study permit application refused on the basis of funds. The background further is that $33,000 was submitted, and is that enough to complain in a judicial review application? In some cases, that could be, depending on the circumstances. I know lawyers tend to say this, depending on this or depending on that. But what I mean, for example, is some people, they could say that I have this source of funds, plus I have a relative in Canada who I'm staying with, so I don't need the amount of settlement funds. So in that case, the norm that is required can be relieved or muted in that kind of situation. So that's one example where you may not need to show the sort of standard amount that's been imposed since January 2024, like some other source of support, like the financial support of a Canadian relative you might be residing with, who might live near the institution you're going to study at. But for that, really, that's really something you have to consult about, because as you could guess, judicial review is expensive. You want to make sure that there is at least the rudiments of a um, good argument before embarking upon that. And that would require looking at the circumstances, looking at when you filed the application to see which numerical amount of settlement funds were recommended on the immigration website, etc. And then you'd come to the conclusion with your lawyer, such as us, for example, if you retain us, about whether there is sufficient merit to judicial review against a refused study permit application. So with that in mind, we have 3 minutes. I don't see, well, I think somebody might have joined. I heard something, right? So yeah, it looks like we have sort of a bookend type question. So this kind of bleeds into the sort of outro I have for these webinars. So here at Chaudhary Law Office, this is a 3-lawyer law firm. I'm the managing lawyer, and we have webinars usually on the third Thursday of the month at 6 p.m. Eastern Daylight Time for 1 hour. These are promoted from time to time just to sort of get the word out. And the whole purpose is just to get past that barrier that people have, which is, dealing with a lawyer could be kind of frustrating, and they want money right away for a consultation. But by contrast, this is meant to provide some direction, which I think is sorely needed, because with the proliferation of various sources, not just the official Canadian website, but various fora, there are anecdotes that people give, and that's sometimes misinterpreted as advice that people follow to their detriment. It's kind of like when you have a medical issue and you look up WebMD and you look up a bunch of symptoms and you think you have cancer, and you just may have some weird nodule on your face or something. So this is also meant to acquaint you with our law firm that has been in existence since 1995, and I've been in the immigration law practice for 30 years. And so this is an opportunity to demonstrate sort of the broad-ranging experience that we have with all kinds of applications. So with that in mind, I think we're almost at time, and I do not see any other questions. So I want to thank you very much, and I hope this was useful. And you can look us up on www.chaudharylaw.com. So that's www.chaudharylaw.com. If you want to reach out for some further questions, or maybe some other kind of service, such as a visa application or seeking redress against a negative visa application through the Immigration Refugee Board or through the federal court. So it looks like we're almost at 7 o'clock, so enjoy the rest of your evening. Goodbye.